Yes.
May it please my Lord. Abdullahi Aliyu. I appear for the first respondent.
You have your list?
Yes, my Lord, we submitted a list.
Yes.
Appearing with me, my lords, are my learned friends, T.M. Inua, S.A.N., T.M. Inua, S.A.N.,
Yes.
S.O. Ibrahim, S.A.N.,
Yes.
Aminu Sadauki, number 6, my lord, of the Ottawa, and Z.O. Obansa, Esquire. That's the last name on the list, my lord.
Sadauki
Yes, my lord.
and
Z.O. Obansa, Esquire.
for first
For the
respondent?
first respondent, my lord. Thank you,
Yes.
my lords.
Yes.
Most respectfully, your lordships, my name is Akintola Makinde. We submitted a typewritten list to your lordships, and I appear with my colleague, Okpeyemi Muritala.
What we have here is Okpe Moritala.
As the court pleases,
Is it Okpe or Okpeyemi?
Okpe Muritala, as the court pleases. As the court, I was using my
Which one
my
do you
native
want us to
knowledge.
write? Is it Okpe or Okpeyemi?
My lord, he prefers Okpe Muritala,
Okay.
as the court pleases. Very respectfully, our appearance is for the second respondent.
Okpe, what is your name on the roll of legal practitioners?
Muritala
Hmm?
Muritala.
That's the name you have on the roll of legal practitioners. After you have been called to the bar, registered here in the Supreme Court with those three names, you now went and gave yourself Okpe and move about. The day you sign a document and bring, they say this is not your name. It will take you like 3, 4, 5 years to do a case in court to regularize your name. So you better go back to the register of legal practitioners and know what name is there. But for today, you say you're Okpe. Of course, one day we'll ask you to show whether you are really
What by
Okafor and Weke.
Okafor and Mweke?
Yes?
With profound respect, my lord, Olumide Olujimi. My lord, my appearance is for the third respondent.
Yes?
Appearing with me are my learned friends.
Olumide, you are Esquire.
Yes, my lord.
Okay.
Appearing with me are my learned friends, Professor Abdul Karim Kana.
Professor,
Yes. May Sorry, my lord.
can you put on, you say what?
I said my name was not submitted, my lord. I'm so sorry.
What is your name?
Professor Abdulkarim Kana. I'm so sorry.
You are SAN,
No, I'm live bencher, my lord.
live bencher.
Yes, my lord.
You don't want your name to appear.
No, it wasn't. It was omitted.
Professor
Abdulkarim Kana, my lord.
Abdul Karim.
Kana.
What?
Kana, K-A-N-A, my lord.
K-A-N-A.
Yes, my lord. As in Kanu, but the last one will be an A, not O, my lord.
Yes.
Respectfully, my lord, also appearing with me is Abdul Wahab Abayomi.
Yes.
My lord, our appearance is for the third respondent. Most respectfully, my lord.
This judgment was prepared by me, and I will deliver it. Well, this is an appeal against the judgment of the Court of Appeal, sitting as the Presidential Election Petition Court in suit number CA/PEPC/05/2023, which was delivered on the 6th of September 2023. In the said judgment, the court below substantially sustained the respondent's objections to the petition, the petitioner's reply to the respondent's respective replies, the competence of witnesses subpoenaed by the petitioners, and the admissibility of several documents sought to be tendered by the appellants. After resolving all the issues in favor of the respondents, the lower court dismissed the petition for lacking merit. Dissatisfied with the dismissal of the petition, the appellants filed a notice of appeal on the 18th of September 2023. A brief facts of the case giving birth to this appeal are that election into the office of President of the Federal Republic of Nigeria was conducted by the Independent National Electoral Commission, INEC, on 25th February 2023, wherein the second and third respondents emerged winners with a total of 8,794,726 votes, while the appellants came second with 6,984,524 votes. 16 others participated in the said election. The first respondent accordingly declared the second and third respondents winners of the election and declared the second respondent as the elected president of the Federal Republic of Nigeria. Aggrieved by the outcome of the election, the petitioners jointly filed a petition at the court below to challenge the outcome of the election under 4 grounds as follows. A, that the election of the second respondent is invalid by reason of non-compliance with the provisions of the Electoral Act 2022. B, that the election of the second respondent is invalid by reason of corrupt practices. C, that the second respondent was not duly elected by a majority of lawful votes cast at the election. And 4, the second respondent was at the time of the election not qualified to contest the election. The appellants as petitioners then sought the following reliefs. 1, that it may be determined that the second respondent was not duly elected by a majority of lawful votes cast in the election, and therefore the declaration and return of the second respondent by the first respondent as the winner of the presidential election conducted on the 25th day of February 2023 is unlawful, wrongful, unconstitutional, undue, null and void, and of no effect whatsoever. That it may be determined that the return of the second respondent by the first respondent was wrongful, unlawful, null and void, having not satisfied the requirements of the Electoral Act 2022 and the Constitution of the Federal Republic of Nigeria 1999 as amended, which mandatorily requires the second respondent to score not less than 1/4 or 25% of the lawful votes cast at the election in each of at least 2/3 of all the states in the Federation and the Federal Capital Territory, Abuja. That it may be determined that the second respondent was at the time of the election not qualified to to conduct the said election, to contest the said election. That it may be determined that the first petitioner, having scored the majority of lawful votes cast at the presidential election on Saturday, 25th February 2023, be returned as the winner of the said election and be sworn in as the duly elected president of the Federal Republic of Nigeria. In the alternative, number 5, an order directing the first respondent to conduct a second election that is run-off between the first petitioner and the second respondent. In the further alternative, 6, that the election to the office of the President of Nigeria held on the 25th of February 2023 be nullified and a fresh election rerun ordered, and any further reliefs as the court may deem fit to make in the interest of justice. Upon being served with the petition, all the respondents joined issues with it by filing their respective replies, incorporating preliminary objections, and made other applications. Some of the applications filed by the parties were heard and rulings delivered at the pre-hearing stage, while some were heard and rulings on them reserved till the time of the judgment of the court. On 6 September 2023, judgments in the petition, including rulings in the applications, were rendered by the court below. As I said earlier, the appellant's petition was dismissed. Dissatisfied with the stance of the lower court dismissing their petition, the appellants have appealed to this court. Notice of appeal was filed on the 18th of September 2023, containing 35 grounds of appeal. Appellants filed their brief of arguments on 2nd October 2023, while the first, second, and third respondents filed theirs on the 7th of October, respectively. On 6th October 2023, the appellants filed a motion on notice seeking 2 orders from this court. And at the hearing of the appeal on 23rd October 2023, the said motion was taken first and ruling reserved till today. I shall proceed to determine the said motion before resolving the issues in this appeal. Motion on notice filed on the 6th of October 2023. As I alluded to above, the appellants filed motion on notice on 6 October 2023, seeking 2 orders from this court, to wit, A, an order of this honorable court granting leave to the appellant applicants to produce, and the honorable court to receive fresh and or additional evidence by way of deposition on oath from the Chicago State University for use in this appeal, to wit, certified discovery deposition made by Caleb Westberg on behalf of Chicago State University on October 3rd, 2023, disclaiming the certificate presented by the second respondent, Bola Ahmed Tinubu, to the Independent National Electoral Commission. B, and upon leave being granted, an order of this court receiving the said deposition in evidence as exhibit in the resolution of this appeal. The grounds for the application are well set out in the motion paper, and there are 20 in number as follows. 1. One of the grounds of the applicant's petition before the court below is that the second respondent was not qualified at the time of the election to contest the election, as required by Section 137(1) sub 1 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. 2. Based on facts available to the applicants at the time of filing their petition, the first appellant applicant, through his United States of America lawyers, Alexander D. Gramont, and Angela M. Liu of the law firm of Dockett LLP of 1900 K Street, NW, Washington, D.C. 20006 to 1110, unsuccessfully applied to Chicago State University for the release of the copies of the academic records of the second respondent. Given this, number 3, given the strict privacy laws in the jurisdiction of the Chicago State University, the request for the release of the academic records and certificates issued to the second respondent could not be granted without an order of court and for the purpose of use in pending court proceedings. The first applicant, through his said U.S.-based attorneys, thereupon brought an action in the U.S. District Court for the Northern District of Illinois in re application of Atiku Abubakar for an order directing discovery from Chicago State University, case number 23CV05099, for an order for the production of documents and testimony for use in a proceeding in a foreign court, seeking documents and testimony from Chicago State University concerning the authenticity of an origin of documents purporting to be the educational records of the second respondent, Bola Ahmed Tinubu. 5. The second respondent applied and was joined in the matter as an intervenor, vehemently opposing the application. On September 19, 2023, the court issued an order granting the application. 7. Thereafter, the second respondent applied for an emergency stay of the court order, claiming that he would suffer irreparable damage and injury if his educational records were released, which order of stay was granted. 8. On September 30, 2023, the court overruled the second respondent's objections and ordered Chicago State University to produce the documents on October 2nd, 2023, and to produce a witness for deposition on October 2. Then on October 2, 2023, Chicago State University produced the documents pursuant to the court's order. 10. On October 3, 2023, also pursuant to the court's order, Chicago State University provided a witness to give deposition testimony, in which deposition Chicago State University disclaimed ownership and authorship of the document that second respondent presented to INEC, purporting to be Chicago State University certificate, and also disclaimed issuing any replacement certificate to him. The deposition was not in existence, or that's number 11. The deposition was not in existence or available at the time of filing the petition or at the hearing of the petition. The deposition number 12 sought to be adduced is, along with its accompanying documents such as would have important effect in the resolution of this appeal. 13. The deposition is relevant to this matter, having confirmed that the certificate presented by the second respondent to the Independent National Electoral Commission did not emanate from Chicago State University, and that whoever issued the certificate presented by the second respondent did not have the authority of the Chicago State University, and that second respondent never applied for any replacement certificate, nor was he issued any replacement certificate by Chicago State University. The deposition which is on oath, that's number 14th ground, the deposition which is on oath deposed to in the presence of the second respondent's attorney is credible and believable and ought to be believed. 15. The deposition is clear and unambiguous, and no further evidence is needed to be adduced on it. 16. The evidence is such that could not have been obtained with reasonable diligence for use at the trial, as the deposition required the commencement of the suit in the United States of America before receiving same. it was not possible to obtain the said evidence before the trial at the court below. 17. The deposition was made on October 3 after the conclusion of trial at the court below and was not available to be tendered at the trial court. 18. Presentation of a forged certificate to the INEC by a candidate for election to the office of President of the Federal Republic of Nigeria is a weighty constitutional matter requiring consideration by the court as custodians of the Constitution. 19. The original certified deposition has been forwarded to the Honorable Court by a letter addressed to the Chief Registrar of the Supreme Court. And 20, the last, it is in the interest of justice for this Honorable Court to exercise its discretion in favor of the appellant's applicants. In support of the said application is a 20-paragraph affidavit deposed by Uyigiwa Osage, Nigerian citizen, a legal practitioner, and legal advisor to the first appellant, with exhibits A to H annexed. Learned Senior Counsel for the appellant applicants, Chief Chris Uche, SAN, leading other senior and other counsel, filed a written address in support of the motion. Upon receipt of the said motion on notice, the first respondent filed an 11-paragraph counter affidavit deposed by one Gift Nwadike, a legal secretary in the law firm of Diko and Mahmood, lead counsel to the first respondent. A written address in opposition to the said motion was also filed and signed by A.B. Mahmood SAN, lead counsel for the first respondent. For the second respondent, Senator Michael Okpeyemi Bamidele, a legal practitioner and long-standing associate of the second respondent, deposed to a counter affidavit of yet again 20 paragraphs on 12 October 2023. Annexed to the counter affidavit are exhibits 1 to 9. And in support of the counter affidavit and in opposition to the motion, Learned Senior Counsel for the second respondent, Chief Wole Olanipekun SAN, leading senior counsel and leading other counsel, filed a written address on the same date the counter affidavit was filed. The third respondent's counter affidavit was deposed to by one Peter Emma Iko, a legal executive in the law firm of Olujinmi and Akeredolu, lead counsel for the third respondent. The 9 paragraphs counter affidavit is supported by a written address filed and signed by Chief Akin Olujinmi SAN. Upon receipt of the various counter affidavits, the appellants filed a further affidavit of 20 paragraphs deposed to by the same Uyi A. Giwa Osage, with 12 exhibits further annexed. Learned Senior Counsel also filed reply on points of law to the written addresses filed by the first, second, and third respondents in their opposition to the appellant's motion on notice for fresh evidence and or additional evidence. At the hearing of this motion, both the applicants and the respondents adopted their supporting and counter affidavits respectively. They also adopted and relied on their various written addresses. In the applicant's written address, the Learned Senior Counsel submitted one issue for determination, to wit, whether this Honorable Court ought to exercise its discretion in favor of the appellant applicants by granting the prayers sought. The first respondent's Senior Counsel also donated a sole issue for determination as follows: whether in view of the peculiar facts of this case, this Honorable Court can proceed to grant the instant application. For the second respondent, Chief Olanipekun SAN, submitted one issue, which states, considering the background of this case, as well as the applicable constitutional and statutory provisions relevant to election appeals and proceedings, whether this Honorable Court will grant this application. Finally, Chief Akin Olujinmi SAN, leading other counsel for the third respondent, opined that the crucial question to be addressed in this motion is whether this court has jurisdiction to entertain this application. Now, taking a clinical look at the four issues, it is crystal clear that they all say the same thing. And put in simple terms, it is whether the law of Nigeria, as presently constituted, allows this court to receive the evidence in question and act on it at this stage. In his argument, the learned senior counsel for the appellants submitted that this court has the power, the jurisdiction, and the discretion to grant an application to adduce fresh and or additional evidence on appeal, referring to Order 2, Rule 12.1 and 2, and Rules 12.1, 2, and 3 of the Supreme Court Rules, and the case of Uzodinma and Izunaso, citations supplied, the learned senior counsel submitted that the grant of this application will be in furtherance of the cause of justice, that this is a case in which the second respondent was purportedly declared as the winner of the election to the office of President of the Federal Republic of Nigeria, and the applicants have, amongst other grounds, challenged the election of the second respondent on the ground that the second respondent presented a forged document to the Independent National Electoral Commission, that the appellants have also a challenge in their appeal the striking out of their pleadings raising the issue of qualification of the second respondent to contest the said election. Learned Silk also relied on the cases of Nigerian Customs Service Board and Innocent and other cases cited in this judgment. According to the Learned Silk, the evidence required to establish that the certificate presented by the second respondent to the first respondent in support of his qualification to contest the said election is the deposition from the Chicago State University, which deposition did not become available until after the determination of the case by the lower court. He contended that the appellant applicants have successfully explained the delay and difficulties in obtaining the said evidence earlier than now. Relying on Saleh and Abba citations supplied, the learned senior counsel urged this court to resolve the sole issue in favor of the appellants and grant the application. In response to the above argument, the learned senior counsel for the first respondent, A.B. Mahmoud Esen, submitted and urged this court to dismiss the appellant's application as they have failed to meet the conditions for grant of same. He opined that election petitions are sui generis, and as such, this court, in determining this application, must take into consideration the peculiarity of the instant appeal, which is an appeal against the judgment of the Court of Appeal, sitting as the Presidential Election Petition Court, and based on the provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended, and the Electoral Act 2022. He stated the three conditions that has to be met before the fresh evidence can be admitted, and he urged this court to hold that the appellant's applicants failed to fulfill the conditions. In this, he relies on the case of Adeleke and Aserifa, Wata and Anyago, UBA PLC and BTL Industries, all citations supplied, amongst others. It is his contention that the appellants were tardy and were not reasonably diligent in their attempt at obtaining the documents which they seek to be received in these proceedings, that having not acted with reasonable diligence, this court ought not to grant the instant application, also relying on Obo and NFLS Limited. Oh my God. Learned Senior Counsel also drew the attention of this court to the decision of the court below, which has not been appealed against, that the petition did not plead facts in support of non-qualification or disqualification of second respondent in their petition, and that their efforts to remedy it through their replies to respondents' replies were belated and were rightly refused. According to him, the deposition of Caleb Westberg is irrelevant since the appellants did not raise the issue of forgery at the lower court. And relying on the case of Okwe Kenye and registered trustees of Jude Anglican Church, citation supplied is submitted that evidence not supported by pleadings goes to no issue. Leonard Silk further submitted that insofar as the deposition of Caleb Westberg is solely to disdain the certificate presented by the second respondent and attached to his form EC9 dated 17 June 2022, which the first respondent published as far back as 4th of June 2022, the appellant's complaint in that regard is pre-election matter, which by section 285(9) of the Constitution of the Federal Republic of Nigeria is statute barred. As such, an action ought to have been initiated within 14 days of the second respondent's submission of his form EC9 or the publication by the first respondent. He urged the court to so hold. According to Leonard Senior Counsel, an allegation of presentation of false or fake certificate is rooted in the criminal offense of forgery, which requires proof beyond reasonable doubt. He contended that the deposition by Caleb Westberg, which seeks to establish a case of forgery against the second respondent without more, cannot ground a conviction for forgery of as proof beyond reasonable doubt cannot be solely based on an affidavit evidence, relying on Abubakar and INEC, Agi and PDP, Mohammed and Wamako, all citations supplied. Leonard Silk argued further that the deposition of Caleb Westberg alone does not, under our law, constitute credible evidence to establish a case of forgery. Finally, the Leonard Silk submitted that this appeal, being based on an election matter, where a trial court is to hear matters and deliver judgment not later than 180 days after the filing of the petition, the implication is that all evidence ought to be adduced at the trial court and judgment delivered within 180 days. That it was not the intention of the draftsman of the Constitution to allow and permit the receipt of evidence in an election matter when the court vested with the powers to receive evidence, has lost jurisdiction over the matter. He wondered what would happen now that all parties have filed and exchanged briefs with no arguments canvassed in respect of the additional evidence sought to be adduced in the instant appeal. There being no room to extend time under the pre-election and election appeals practice directions 2023 of the Supreme Court, he urged the court to dismiss the application. In his contribution in opposition to the grant of this application, Leonard Senior Counsel for the second respondent, Chief Olanipekun SAN, submitted that this court is without the virus to consider the said deposition either as oral or documentary evidence, more so when the evidence was not considered by the court of first instance within the 180 days time frame provided by the Constitution of the Federal Republic of Nigeria, relying on the recent case of Towo Womo and Ajayi, unreported, delivered on the 27th of January 2023 in this court hall. That the lower court, having lost its jurisdiction since 17 September 2023, upon expiration of the 180 days from the date of filing the petition by the appellants, this court cannot grant this application. That section 22 and 23 of the Supreme Court Act give power to order 2 Rule 12(1) of the rules of this court, and that can only happen if the lower court still has jurisdiction. Referring to Omubilari and Igbo Asoyi and others, and Adegbite and Omosun, all citations supplied, the Leonard Silk contended that applicants failed to satisfy the 5 conditions enunciated in those cases before this type of application can be granted. According to the learned SAN, the failure of the applicants to have validly pleaded facts and documents sought to be received in evidence is fatal to this application, relying also in Obasi and Onwuka Start Oil, Nigeria Limited and Induction, and others, all citations supplied. Making reference to the USA Rules on Civil Procedure 32A1A, the learned Silk opined that the failure to invite the All Progressives Congress and the Independent National Electoral Commission to participate in the deposition made in the United States renders Exhibit C and D inadmissible. More so, since the alleged forged certificate is alleged to have been submitted to INEC. It is further contention that Exhibit C and D have no utility or affinity with this appeal for the fact that there is no ground of appeal upon which they can be structured, as well as there being no accommodative issue for determination, relying on a number of cases listed in this judgment. Finally, learned senior counsel submitted that Exhibit C, D, unpretentiously attempts to allege a criminal offense of forgery against the second respondent. You find that a criminal offense must be proved beyond reasonable doubt, as provided in Section 135 of the Evidence Act, also referring to the cases of ACN and Nyako and Kaki and PDP. He concluded that the Supreme Court does not have original jurisdiction to try the case of forgery. He urged this court to refuse this application and hold that it is an abuse of court process. For the third respondent, Chief Akin Olujimi SN made submissions which are similar to those by the learned counsel for the first and second respondents. With due respect to the learned Chief Silk, I shall refer to them in the process of resolving the sole issue in this application. In the applicant's reply on points of law, learned senior counsel listed some paragraphs of counter affidavit of the second respondent, which he alleges consists of legal arguments, objections, and conclusions, which he urged that they be struck out. On issue of jurisdiction, he submitted that Section 285(6) of the Constitution, which pegs 180 days for the hearing and determination of the election petitions, does not include the Court of Appeal, but only election tribunals. Learned Silk submitted that issue of qualification is for both pre- and post-election matters, referring to Section 137(1)(j) of the Constitution. He urged the court to grant this application in the interest of justice, as was done in Amechi and INEC and Obi and INEC, all citations supplied. In resolving the sole issue submitted for the determination of this motion, I wish to start from the beginning. And the beginning is the issue of jurisdiction. Whereas the respondents in their various written addresses have urged this court to grant not to grant this application as it is an exercise in futility. They opine that the Supreme Court does not have jurisdiction to look into or act on Exhibits C and D if admitted into the proceedings. The learned senior counsel for the appellants submitted otherwise. I have already summarized their various positions, and I shall refer to them as we proceed. It is elementary to state that the jurisdictional court is the authority which a court possesses to decide matters brought before it. or to take cognizance of matters presented in a formal way for its decision. In an old case of Ogun Makun and Milad, Osun State, citation supplied, this court stated as follows: jurisdiction of the court is the basis, the foundation, and the live wire of access to court in adjudication under Nigerian civil process. As courts are set up under the Constitution, decrees, acts, laws, and edicts, they cloak the courts with the powers and jurisdiction of adjudication. If the Constitution, decrees, acts, laws, and edicts do not grant jurisdiction to a court or tribunal, the court and the parties cannot, by agreement, endow it with jurisdiction, as no matter how well intentioned and properly conducted the proceedings, once it is incompetent, it is a nullity and an exercise in futility. End of quote. The jurisdiction of a court has further been defined as the very fundamental and priceless commodity in the judicial process. That is to say, it is the fulcrum, the centerpiece, or the main pillar upon which the validity of any decision of any court stands and around which other issues rotate. Thus, it cannot be assumed or implied. It cannot also be conferred by a party. Where there is an appeal, it shall be determined within 60 days from the date of delivery of judgment of the tribunal or court of appeal, as pointed out by learned senior counsel for the respondents. The 180 days prescribed for the hearing of the petition by the Court of Appeal lapsed on the 17th of September 2023. In other words, the court below lost its jurisdiction to determine any matter in relation to the petition. This application before us relates to fresh evidence obtained after the judgment of the lower court and after the 21 days for filing election petition and after the expiration of the 180 petition. What are the legal and or constitutional implications of the above scenario in relation to Exhibits A and D sought to be received into these proceedings? Several of the decisions of this court have taken care of the above scenario. One of the most recent cases decided by this court is the case of Towo, Womo, and Ajayi, the citation supplied there, wherein this court stated as follows, and I'll quote: in the circumstance of this case, this court cannot activate Section 22 of the Supreme Court Act 2004, since the 180 days provided by the Constitution to determine the appellant's claim at the trial court has lapsed since 1st January 2023. The originating summons was filed on the 5th of July 2022 and expired on 1st January 2023 at the Federal High Court. This appeal was taken on 2nd January 2023, and there is no opportunity for the contentious issues of fact in the controversy in this appeal to be sent back to the trial court. The issue of the merit of the allegations of false information was not tried by the two lower courts and cannot be tried by this court pursuant to Section 22 of the Supreme Court Act. This court cannot do what the trial court is no longer constitutionally permitted to do by virtue of Section 285 of the Constitution of the Federal Republic of Nigeria, the Groundnam. See OK, Mimiko, see APC, and Marafa, all citations supplied. As stated by the appellant applicants in their application, the reliefs they seek is an order of this court granting them leave to produce, and for this court to receive fresh or additional evidence by way of deposition on oath. Clearly, the application runs foul of paragraphs 14 sub 2 and 16.1 of the first schedule to the Electoral Act, which inter alia outlaws any amendment of substance, as in this case, or introduction or addition of substance to the statement of facts relied on to support the ground of the petition after the expiration of 21 days prescribed in Section 132, Sub 7 of the Electoral Act for the presentation of an election petition. There is no doubt that the deposition is one of substance, and that is in fact why the appellants are seeking to introduce it into this appeal. For the avoidance of doubt, I shall reproduce Section 14.2, paragraph 2, 2A of the first schedule to the Electoral Act 2022 as follows. After the expiration of the time limited by A, Section 132(7) of this Act for presenting the election petition, no amendment shall be made. No amendment shall be made. 1. Introducing any of the requirements of paragraph 4.1 not contained in the original election petition filed. Or 2. Effecting a substantial alteration of the ground for or the prayer in the election petition. Or 3. Except anything which may be done under subparagraph 2A2, effecting a substantial alteration of or addition to the statement of facts relied on to support the ground for or sustain the prayer in the election petition, end of quote. Nothing can be clearer than the above provision, which clearly states that a petitioner shall not be permitted to amend his petition after 21 days allowed by Section 132 sub 7 of the Electoral Act. The applicants herein have not even applied to this court to amend their petition in order to reflect the fact of forgery, and Exhibit C and D sought to be admitted into the proceedings. Facts and documents which were not pleaded in the petition have no place in deciding the dispute between the parties. I still wonder how the appellants intend to use those documents in this appeal. Let me consider an unusual submission of the learned senior counsel for the appellants applicants. It is in respect of Section 285 sub 6 of the Constitution, which states, an election tribunal shall deliver its judgment in writing within 180 days from the date of filing the petition. But on page 3, paragraph 2.5 of the appellant's reply on points of law, he argued as follows, quote, interestingly, and contrary to the avowed position of the respondents, we make bold to submit that there is no such constitutional limit of 180 days on the lower court to hear and determine a presidential election petition, such that can rob this court to exercise its jurisdiction in any manner whatsoever. While establishing the election tribunals to deal with election matters from houses of assembly, National Assembly and governorship elections, the Constitution gave jurisdiction to entertain disputes from presidential elections only to the Court of Appeal. Thereafter, the Constitution was intentional and deliberate in setting the 180 days limit only for elections tribunals and not for the Court of Appeal, end of quote. It is shocking to have the above argument in print. It could have passed for a friendly joke, but not for a serious matter like this in the apex court. It is even an unnecessary joke over a constitutional provision. After election petitions had suffered under the previous provisions, which allowed election petitions to be heard even until the respondent has completed his tenure, and the National Assembly dealt with the mischief by limiting the time which election petitions shall be determined, it is unfair to suggest that we go back to those dark days. My lords, there is nothing in section 285(6) of the Constitution to suggest that the Court of Appeal can hear presidential election petition without time limitation. The lower court is bound by the provision of section 285(6) of the said Constitution when sitting to hear election petition, just as other election tribunals, as was rightly submitted by the learned senior counsel for the third respondent, Chief Akin Olujimi SAN, for which I wholly agree. The appellants knew they had to prove the allegation of non-qualification raised at paragraph 16D and 146 of their petition against the second respondent within the 180 days adjudication window provided in section 182 sub 8 of the Electoral Act 2022 for determination of petition by the lower court, which expired since 17 September 2023. The 180 days having expired, the lower court therefore no longer had jurisdiction to allow the deposition sought to be introduced into the trial of this petition. This is the law which at this stage is elementary. Consequently, since the lower court no longer has jurisdiction to entertain any such application, it follows ipso jure that this Supreme Court, also has no jurisdiction to allow the deposition to be used in this appeal. It is settled law that where the time for doing a thing is limited by the Constitution or statute, the court cannot extend the time. That was the decision of this court in Brigadier General Mohammed Buba Mawar and Admiral Morotala Nyako, where Onogan JSC, as it then was, held as follows. Quote, it is settled law that the time fixed by the Constitution for the doing of anything cannot be extended. It is immutable. It is fixed like the rock of Gibraltar. It cannot be extended, elongated, expanded, or stretched beyond what it states. See also Abubakar and Nassam, all citations supplied. It has to be noted, as I stated earlier in this ruling, and for which there are several judicial decisions in this country, that the 180 days imposed on election tribunals and courts hearing election petitions is immutable and cannot be extended. The applicants have not even applied for extension of time to bring in the said depositions or extension of time to amend their petition. Let me say it clearly that the 21 days provided for the filing of petitions having long expired, even if the appellants had applied for extension of time to amend their petition in order to bring in the depositions, it would not have been granted based on the provisions of the Constitution and the Electoral Act. This principle was again restated by yet again Onogan JSC as it was in NNPP and Goni. Citation supplied when he said, despite the decision of this court since October 2011 on the time fixed in the Constitution, some of the justices of the lower court still appear not to have gotten the message. From where will the election tribunal get the jurisdiction to entertain the retrial after expiration of the 180 days assigned by the Constitution? The answer is obviously in the negative. It should be constantly kept in mind that prior to the provisions of section 285(6) of the 1999 Constitution as amended, there was no time limit for the hearing and determination of election petition by the election tribunals or the appeals arising therefrom. That situation resulted in undue delay in the hearing and determination of an election petition by the election tribunals or appeals arising therefrom. The amendment to the original section 285 of the 1999 Constitution by allotting time within which to hear and determine election petition and appeals arising therefrom is designed to ensure expeditious hearing and conclusion of election matters. If the decision of the lower court is allowed to stand, as urged by the respondents, it will reintroduce the earlier mischief which the amendment sought to correct. End of quote. See also Uba and Suswan, Citation supplied. The above statement by this court is very explicit, clear, and simple. As it is, the provision of the Constitution has spoken. There cannot be an addendum or another reopening of the case at the lower court, its jurisdiction having lapsed. My noble lords, I've taken time to state the law on the issue to show the futility of this motion. It cannot be granted. The jurisdiction of this court is donated by the Constitution and the Electoral Act regarding election petition appeals. We do not have the virus to admit the position, and we cannot invoke Section 22 of the Supreme Court Act, since the lower court has since lost its jurisdiction. More so, there is no paragraph of the petition to accommodate a case of forgery. Again, the appellants have distilled 7 issues for the determination of this appeal, and none relates to certificate forgery. One wonders what the appellants intended to do with the deposition, since appeals are heard on the issues distilled for determination by the parties in this court. In Saliba and Jackson, 2002, for Nigeria Law Report, citations, others supplied. This court stated clearly that all appeals are decided upon the issues formulated for determination. What this means is that any matter not covered by any issue for determination is of no moment. Should the deposition be admitted, it will float in the appeal, as this court cannot exercise original jurisdiction even if we are to start a new case for the appellants. See Sanusi and Ayula, Chitex Industries, and Oceanic Bank, citations supplied. Finally, my noble lords, on this application, I wish to state that fresh evidence is not received as a matter of course. There are conditions which must coexist before the court can grant this type of application, as can be garnered from the decided authorities of this court, which include, that's all right, but not limited to Omu, Boariri, and others, and Igbo, Oyosi, and others, Supra. Adegbite and a motion are cases cited by the Senior Counsel by the second respondent. Simply put, the conditions for the grant of this type of application are that 1, the fresh evidence could not have been obtained with reasonable diligence at the trial. 2, such evidence, if admitted, would have important effect on the subject of the appeal. 3, such evidence ex facie is apparently capable of being believed. 4, such evidence would have influenced the judgment of the lower court in favor of the appellants had it been available. And 5, and if such evidence is admitted, further evidences from the opposing party would not be needed. Taking the first condition, for example, the appellants failed to convince this court on why it waited until after the court below delivered judgment in the petition and lost the 180 days donated to it by the Constitution before bringing the said deposition sought to be admitted in this court. It has to be noted that appeals are a continuation of hearing of the matter in the lower court. As was pointed out by the learned senior counsel for the first respondent, A.B. Mahmoud Essay, the presidential election was conducted on the 25th of February 2023, and the first respondent declared the second respondent as winner of the election on 1st March 2023. Thereafter, the appellants filed their petition at the registry of the court below on 21st March 2023. If I may ask, what attempts did the appellants make between the publication of the second respondent's form EC9 and accompanying documents in June 2022, a year more than a year ago, and the date of filing the petition on 21st of March 2023 to obtain the documents from Chicago State University, which could have been used at the trial court? Again, what attempts did the appellants make to obtain these documents between the date of filing the petition and the conclusion of trial. To say the least, the above questions are critical in the quest of this court's efforts to decide whether the new evidence sought to be adduced could have been obtained by the appellants with reasonable diligence for use at the trial. And with due respect to the appellants and their counsel, I think they were a bit tardy and were not reasonably diligent in their attempts at obtaining the documents which they seek to have this appeal. In Adeleke Aserifa Asupra, this court held that where the evidence is available and could with reasonable care and diligence be made available to the applicant at the time of the trial, as in this case, the court should refuse to exercise its discretion to receive such evidence. From all I have stated above, it is crystal clear that the additional evidence by way of deposition of oath does not fit into the issues submitted for the determination of this appeal. The application, my lord, of the appellant applicants in the circumstance is hereby refused and accordingly dismissed.
As court pleases.
I now go to the main appeal. I want to say that the motions filed by the respondents to challenge some issues, grounds of appeal, we have decided to ignore them, strike them out, and hear the appeal on the merits. The latest senior counsel for the appellants distilled 7 issues for determination, all of them, except the last one, the third respondent submitted 6 issues. So we have stated all there are 7 issues in the judgment. You will see them when you get copies. There is no doubt that all the issues submitted by all the parties are similar, and any could be adopted for guidance. I propose, however, to determine this appeal based on the issues as formulated by the appellants. After all, it is their own appeal. Issue 1. The thrust of issue 1 is whether the lower court was right in refusing to hold that the failure of the first respondent to electronically transmit results from polling units nationwide for the collation of results introduced by the Electoral Act 2022 and specified in the regulations and guidelines for the conduct of elections 2022